The law says one thing. The memo says another. Courts will decide. Here is what the legal fight ahead actually looks like. Because the DOJ memo is not self-executing, and the outcome is not determined. The Office of Legal Counsel concluded that the Supreme Court's Olmstead decision did not hold that people with disabilities must be served in integrated settings, even though courts across the country have consistently held that the court did in fact mean for disabled people to be as integrated as possible. The OLC's interpretation is not just contested, it contradicts 30 years of consistent judicial interpretation across multiple federal circuits. The American Association of People with Disabilities was explicit. The Office of Legal Counsel is incorrect in its interpretation of Olmstead, but the fact that their conclusion is unjustified and incorrect doesn't change the fact that they will seek to use said interpretation to hurt disabled people, lock them away, and end their autonomy. The practical risk is not that courts immediately overturn Olmstead. The risk is that states use the DOJ memo as permission to begin cutting community-based services while legal challenges work through the courts over years. The damage happens in the gap between when states act on the memo's permission and when courts eventually rule against it. The DOJ did not respond to NPR's request for it to explain its position and why it is changing course after decades of legal and bipartisan support for community services. They issued the memo. They declined to explain it. The explanation is left to the people who will bear the consequences of it. They issued the permission slip. They declined to explain it. The people who live with the consequences don't get to decline. Every claim, sourced. Every video, a thread. Follow now, because the next one's the part they hoped you'd never connect.